Hi everybody and welcome back to another episode of My Buddy the Lawyer. Again, my name is Adam. I am your host and I'm also a licensed attorney. As always, thank you very much for your questions. Your questions are always keeping us here working very, very hard. This week we have a great question. It's kind of a two-parter. Part one, is it possible to still owe money on a debt even after the lender has repossessed the debted property and sold it at auction? Part two, if so, how long do they have to come after you for that debt? Here's the scenario. Take out a loan to buy a car. You pay it off, but then you run into some financial trouble. Then one morning, you head out to your car. Surprise, surprise, you find your car has been repossessed. As normally happens, your car is then sold at auction. However, the car was sold for less than what you owe, so there's still a balance that you owe on that car. Can the lender then come after you for that balance even after the car is sold at auction? Unfortunately, yes. In many scenarios, they can. You'll want to check the car loan agreement first, but generally, they usually can. Now that we've answered that question, then the next question becomes, well, how long do they have to come after you, to sue you, to collect for that debt that you owe on that car or that piece of property? To find the answer to that question, you'll have to look to your state's statute of limitations. The statute of limitations is a law that tells you how long you can wait before you have to file a lawsuit on something. Generally, the collection of a debt owed on a piece of repossessed property, such as a car, for example, is governed by the breach of contract statute of limitations. You've heard me say this many times before, I'm sure. You'll need to check with a local attorney for your jurisdiction's statute of limitations. In Illinois, the statute of limitations for a breach of contract is 10 years. However, each state may have different statute of limitations. For example, New York, I believe the statute of limitations is 6 years. Statute of limitations is an affirmative defense, meaning that you can argue that the statute of limitations has expired to defend yourself against a collection that is outside of these time limits. Then it becomes up to the court to make a decision as to whether or not the statute of limitations has in fact expired. Now, I really hope that helped. I would be more than happy to answer any follow-up questions you might have. Just keep sending them our way. Again, please send your questions to us on Facebook, on Twitter, or via email. Don't forget to keep watching our videos on YouTube and subscribe to our YouTube channel, and keep sharing our videos with your friends and family. Thank you very much. Take care.